Welcome to Shaping Canada, 150 Years of Landmark Decisions. The Canada we know today wasn't built by chance. Argument by argument, judgment by judgment, it was forged by law within a unique justice system born from the union of the civil law and common law and increasingly Indigenous legal traditions. In this series, we mark the Supreme Court of Canada's 150th anniversary by decoding some rulings that defined our rights, our freedoms, and our collective identity. From criminal law to Indigenous rights and the division of powers, the decisions we chose to share with you are not just ancient history, they still shape our reality today. I am your host, Hugo Martin, and I ask you to join me for exclusive conversations with the 9 justices of the Supreme Court and leading constitutional experts as we uncover the context, the impact, and the lasting legacy of these judgments.
Can the government force a nation to rest on Sunday? In this episode of Shaping Canada, we discuss freedom of religion with Professor Howard Kislowicz. Howard Kislowicz is an associate professor at the University of Calgary's Faculty of Law, specializing in constitutional law and religious freedom. Our focus today is the landmark decision of R v. Big M Drug Mart from 1985, a ruling that shaped religious freedom in Canada. In 1982, a drugstore in Calgary was charged for selling goods on a Sunday, violating the Lord's Day Act, a law rooted in Christian observance. Big M, a supermarket-style drugstore, challenged the law, arguing it violated the then-new Canadian Charter of Rights. But could a for-profit corporation claim religious freedom? And could a law with a religious purpose survive in a secular, multicultural society? The court's ruling set the stage for how we understand freedom of conscience today. I am Laurence Thériault, and I hope you'll enjoy this episode.
Professor Kislowicz, thank you very much for being with us today, and welcome to Shaping Canada, 150 Years of Landmark Decisions.
It's a pleasure to be here with you, and thank you for the kind invitation.
We are talking religious freedom. We're going to do an analysis of landmark decisions because I think we cannot just use one. In the Canadian Charter, the first individual freedom is the freedom of conscience and the freedom of religion. Is there a reason why it's so early in the Charter?
That's a really good question, and we don't have an account of why it's placed sort of lexically prior to all of the other freedoms in the Charter. Sometimes it's called the first freedom when folks want to shine a spotlight on it. But of course, we know from the Supreme Court of Canada that there is no hierarchy of Charter rights. One is not more important than the other. They're all of equal force. So in some senses on the legal side, it doesn't really matter what comes first. Although, if you are an advocate for religious freedom, you might emphasize, this is not some afterthought.
Broadly speaking, what is freedom of religion?
There's significant variation from one polity to another as to what it means and how far it extends. But usually, what polity or an international agreement adopts freedom of religion, it implies some limit on legislative authority, so a limit on what laws can be passed or enforced. And so far as they compel individuals to do anything contrary to their religious beliefs, or they prohibit individuals and communities from doing anything required or connected to their religious beliefs. Usually, it also is interpreted as requiring some guarantee of state religious neutrality. The principle of state religious neutrality can vary from one country to another, but the core is prohibiting laws that require somebody to act contrary to their beliefs or prohibit them from acting with their beliefs.
Prior to 2A of our charter, what was the landscape? What did it look like?
In Canada, there were a number of important cases that touched on questions of freedom of religion. So there was a series of cases, mostly originating in Quebec, having to do with the province's harsh policies towards Jehovah's Witnesses. So the landmark cases here are Chaput and Romain and Roncarelli and Duplessis. In all those cases, we see the state using its authority to treat Jehovah's Witnesses quite harshly, either having facially neutral laws that are only enforced against Jehovah's Witnesses, or having the premier, who was also the attorney general, use his authority to revoke a liquor license of one individual as a kind of punishment for that individual posting bail for other Jehovah's Witnesses.
Or put a padlock on on the entrance door of one of their churches.
Exactly. So those were some of the controversies. And when those cases reached the Supreme Court, of course, there was no charter, right? This was the 1950s. And the thinking in those cases was the 1867 Constitution Act says in its preamble that Canada will have a constitution similar in principle to that of the United Kingdom. And from those very bare words was extrapolated the idea that, well, the United Kingdom's constitution requires democracy. It has a constitutional principle of democracy. And one cannot have a functioning democracy without certain fundamental freedoms being protected. Freedom of expression was of primary importance in those cases, but freedom of religion was also highlighted as an essential freedom to a constitutional democracy. If you read those decisions carefully, you can see the social mores of the time reflected. So there is a line by Justice Rand who notes that Christianity is of first rank in importance in Canada. And that was the case in those days. And to the extent that the 1867 Act had some protection for religious minorities, these were reserved for Catholics and Protestants. So it was only forms of Christianity that were protected by the 1867 Act specifically. In 1960, we see the federal parliament adopt what's called the Canadian Bill of Rights, sort of thought as a precursor or an antecedent to the Charter. It is more limited than the Charter in a couple of ways. First of all, on its face, it only applies to federal legislation. So it doesn't affect any provincial law. It cannot affect any provincial law. And second of all, even though it says that any statute in Canada inconsistent with the Canadian Bill of Rights is of no force and effect, it itself is not constitutionally entrenched in the same way that the Charter of Rights is. So theoretically, by a majority vote of Parliament tomorrow, the Canadian Bill of Rights could be repealed without any special procedure or majority, whereas the Charter would require some kind of amending procedure, which is very hard to accomplish. In part because of this status, and maybe because of the social mores of the time, the Canadian Bill of Rights protection of freedom of religion was not quite as robust. Courts seemed less confident relying on it to invalidate legislation than they have become since 1982 with the adoption of the Charter. So one case I know we'll be talking about a little bit more in detail later today is a case called Big M, which dealt with a constitutional challenge to the Lord's Day Act. That same act was challenged under the Canadian Bill of Rights in a case called Robertson and Rosatoni, and that challenge failed. So same law, same guarantee of freedom of religion, different strength of statute, different social time, different confidence of the judiciary in relying on it. So opposite results. Big M Drug Mart, which is what it sounds like, it's a drugstore, was prosecuted for opening its store on Sunday, contrary to the Lord's Day Act. So this is old legislation. It essentially, without getting into too many details, it requires businesses to close on Sundays, subject to certain exceptions, but in general, it was Sunday closing legislation. Big M Drug Mart wanted to stay open on Sundays. And so they got cited for an infraction under the Lord's Day Act. And as is the right of any person charged with an offense, they raised the argument that it was unconstitutional because of the guarantee of freedom of religion.
The trial judge decided that it was unconstitutional. It was decided that they could open on Sunday. The case was appealed and eventually reaching the Supreme Court of Canada. Now, we understand that Big M says the Lord's Day Act is unconstitutional because it violates the freedom of conscience and religion guaranteed by Section 2A of the Canadian Charter of Rights and Freedom.
Right. Is the Lord's Day Act constitutional or not? And the answer is no. But really, the case has become this monumental precedent that is cited in every subsequent 2A case, because this is the first 2A case to reach the Supreme Court of Canada. And at the time, all of the contemporaneous cases, the Supreme Court knows that it is setting the table for all subsequent charter jurisprudence. It has already decided that it's going to interpret the Charter purposively, and so it needs to provide some account about what the purposes of Section 2A are. in order to lay down the bedrocks of jurisprudence. One important wrinkle in the case is, it's often forgotten now, I think, but Section 15 of the Charter, which guarantees equality, was delayed in application compared to the rest of the Charter. So while most of the Charter comes into force in 1982, there was a 3-year delay on Section 15, presumably because the framers of the Charter understood that this would be the most challenging issue for existing legislation. So to give governments across the country a few years lead time to get their respective ministries of justice to analyze the existing legislation, make what changes needed to be made in their view in order to stem the tide of litigation somewhat.
Do you think that maybe Section 15 should have applied?
Well, it certainly shouldn't have applied in a technical sense, right? It was definitely not in force at the time that Big M Drug Mart was charged with an offense. But there has been some criticism of the Big M case. Some say that properly analyzed, Sunday closing legislation is not a religious freedom problem. It is an equality problem because Sunday closing laws do not require anybody to go to church. They don't require anybody to affirm anything contrary to their belief. All they require is for people to close their shops, which may be thought of as having only a secular consequence. The Supreme Court, Justice Dixon's majority opinion, addressing that issue, and he says specifically he doesn't need to rely on equality. One can't have religious freedom for some and not for others. And so there is an idea of equality inherent. The reason for protecting freedom of religion relates to human dignity. Now, that has been the Supreme Court's theory of the Charter going back a long ways, that if there is a golden thread underlying at least the fundamental rights, but perhaps the whole of the Charter, it is human dignity. And if the reason that I and you are owed freedom of religion is because of our inherent human dignity, neither one of us has more than the other, right? We both have equal human dignity. And so freedom of religion has to apply equally to all, meaning that there is a theme of equality or an idea of an equality inherent in the idea of religious freedom, says the Supreme Court in Big M Drug Mart. So that was a second issue that they had to analyze. Is this really better understood as an equality issue?
The court does say that the Lord's Day Act is forcing Canadians to observe the Christian Sabbath to promote one particular religion. So this is the equality issue that you're talking about, to create some kind of a religious coercion. We're promoting Christianity and we're not encouraging any other religion.
That's exactly right. We see the Supreme Court use the language of coercion when it's setting the basics of what Section 2A requires. But as I said, critics will say, well, nobody is actually coerced to observe the Sabbath, right? People are coerced not to open their stores, but that it might not be an inherently religious act. Whereas what the court ends up saying is it is a kind of coercion, or at least it is a violation of what will later be called in the court's jurisprudence the principle of state religious neutrality. So we may reinterpret now, with hindsight, the wrong brought by the Lord's Day Act, not as a specific religious coercion, but as a violation of state religious neutrality. Because, as you say, it's the state promoting a particular faith, or family of faiths.
The purpose of the law was religious, and this is why it fell under 2A.
Exactly. So one of the things that I like is that you can think about it as demonstrating the links between the 1867 Act and the 1982 Charter. Now, why do I say that? What makes the Lord's Day Act valid federal legislation from a federalism standpoint? Ordinarily, we would think that provinces have jurisdiction over rules relating to businesses because of their powers of property and civil rights. So what business is it of the federal parliament whether some local store in Calgary opens its doors on Sunday? And the reason that the court says this is valid from a federalism perspective is because it's valid under the criminal law power, because it has a moral foundation. It's an attempt to enforce a particular kind of morality. Under subsection 9127 of the 1867 Constitutional Act, the federal parliament has jurisdiction to create criminal law. Ordinarily, we see that expressed in the criminal code, but that power also underlies a host of other federal legislation through tests that have been developed on what counts as a criminal law. And the Lord's Day Act met that test. But the very thing that makes it valid from a federal perspective makes it invalid from a charter perspective, because it's trying to enforce a particular kind of morality, and that morality is religious. It fails under Section 2A in two ways. It fails because it's an infringement of Section 2A, because it adopts a particular religious perspective, and it cannot be justified under Section 1 because it does not have a valid, pressing, and substantial objective underlying it. Specifically, because it is motivated by a religious purpose, that is not on the menu of valid purposes that can underlie constitutional legislation, that can underlie legislation in Canada since the adoption of the Charter. One of the subsequent cases called Edwards Books, and that dealt with a provincial law not called the Lord's Day Act, called the Retail, Business, and Holiday Closures Act or something like that, where the evidence was that the adoption was exactly for a common pause day rather than religious in origin. And the court specifically rejects the idea that a law's purpose can shift over time. You can't say, well, the purpose today is different than it was yesterday. You are stuck with the historical record of what the purpose was. It's kind of hard to say with a straight face that the purpose of this is not religious when it's called the Lord's Day Act. Obviously, the purpose hasn't shifted enough for you to change the title. And so it was not an argument that was successful either on the historical account or on the shifting account.
How can we take this and reapply it later? How is it used going forward?
I would say that there's 2 or 3 really important principles that go forward from Big M. The first and most basic one is that it defines the right of religious freedom. It doesn't exactly give us a test, but it does tell us what the content of the right of religious freedom will be on the liberty-oriented account. I'll quote here from paragraph 94 of the decision, where the court holds that the essence of the concept of freedom of religion is the right to entertain such beliefs as a person chooses, the right to declare religious beliefs openly and without fear of hindrance or reprisal, and the right to manifest religious belief by worship and practice, or by teaching and dissemination. So there are 4 different components that we can identify in this short paragraph. You can believe what you choose to believe. You can declare what you believe and not be punished for it. You can observe religious practices or worship in public, or you can teach or disseminate your religion, what some people might call proselytization. All of those activities are covered in the right of freedom of religion. So that is one deep holding of Big M that gets cited in every subsequent case, because I think they understood the gravity of the task that was on them in the post-1982 moment. This was going to be the first generation of decisions based on the Charter that were going to shape constitutional law in Canada in a way that hadn't yet been seen, and that was going to have a significant impact on the way our democracy functions. I want to say that there's 2 other key principles, I think, that emerged from the Big M case. One is less of a principle and more of an orientation. So the first is the historical account that the court gives to religious freedom around paragraph 120 of the decision. The court tells a story of the reason for religious freedom as coming in post-Reformation Europe, ending the wars of religion. It casts a narrative of religious freedom as a solution to a very deep problem where European countries were going to war one with the other and people were suffering and dying because of religious differences, and religious freedom was the way out. Interestingly, the court notes that this idea also itself, maybe ironically, had religious origin. They say at paragraph 120, attempts to compel belief or practice denied the reality of individual conscience and dishonored the God that had planted it in his creatures. There is a sort of religious foundation to this origin of religious freedom. That's an interesting thing to think about. But also, it casts a particular narrative, and it is not the only available narrative of religious freedom. So some scholars would locate the origins of the idea of religious freedom also in Europe, but in events like the investiture crisis in the church. And the reason this is important, I think, is when we tell the story the way the Supreme Court of Canada does it, we get one version of the right. And when we tell it in this other way, we may get versions of the religious freedom right that are more jurisdictional in flavor. That is to say, more hands-off church organizations vis-a-vis the state, where we don't really get that sense from the narrative cast by the Supreme Court of Canada. The final principle I wanted to point out, which is that it is impossible to justify a law with a religious purpose. And so all subsequent legislation in Canada, even if there may be some religious ideas underpinning it, any government that doesn't want its legislation to be immediately challenged and lose will develop a non-religious account of the law and almost certainly will not put the name of a god in the title. So I think it seems to me like Sunday closing laws are a thing of the past in Canada, for better or for worse.
So let's project ourselves to 2004. Now we needed to decide on other things, on religion, on conscience, on protecting individual religious experiences. Let's go to Quebec, Syndicat Northcrest against Amselem. Can you tell us a little bit about the facts of that case?
In the community of Outremont in Montreal, there was a condominium development, or what they call in Quebec, divided co-ownership, a number of buildings. And there were a number of different co-owners. So Mr. Amselem gets the title of the case, but there were actually two other families along with him, the Kleins and the Fonfetters. They were all Jewish co-owners in this condominium complex. Each of them decided that they wanted to build something called a sukkah. So a sukkah is best described as a hut. There's all kinds of rules in it in Jewish law about what it must look like, but basically it's a rustic hut that is built as a temporary structure in remembrance of the time of the Israelites wandering in the desert. This happens annually for an 8 or 9 day holiday, and these co-owners built on their balconies or terraces a sukkah. Now the problem was that the bylaws in the declaration of the co-ownership fairly clearly prohibited putting anything on the balcony. So it wasn't a specific prohibition on Sukkot, but the Sukkot were clearly in violation. They claim not to have been aware of those particular restrictions. In the facts leading up to the litigation, there is an attempt at negotiation. A Jewish community organization gets involved as a kind of intermediary between the co-owners and the syndicat. The syndicat proposes building a communal sukkah in the internal courtyard of the building, so it wouldn't be visible from the street, so it would meet the goals of the syndicat of maintaining the aesthetic harmony of the outside of the building, but the syndicat thought it would also meet the needs of the co-owners. Initially, there seems to be some acceptance, but then ultimately all of the co-owners decide, no, that doesn't actually meet our needs. The syndicat comes to court seeking an injunction against the co-owners from building Sukkot in the future. But one of the interesting things about the case is because of some of the ambiguities left by Big M, each side of the litigation, so the syndicat and the co-owners, brings an expert witness to testify as to the religious law relating to the sukkah. And so what you end up with at trial is competing expert testimony from two different rabbis. The rabbi for the syndicat says, it is true that there is a requirement in Judaism to dwell in a sukkah. Usually in places with weather like Montreal, that is interpreted as taking one's meals in the sukkah. In places where the weather is more temperate, people sleep in their sukkot. But he said there's a requirement to dwell in the sukkah, but there isn't a requirement to have one's own sukkah. So the religious needs, said this expert witness, of these co-owners could be met through either a communal sukkah or through a sukkah built by their local synagogue, for example. Whereas the rabbi brought by the co-owners said, that's not the way I understand the obligation, because not only is there an obligation to dwell in the sukkah, there is an obligation to celebrate the holiday joyously. And if the circumstances are such that the sukkah you're using is interfering with the joy of your celebration, then you're actually not meeting your religious requirements. And so we had competing rabbinic testimony about the content of the religious obligation. The trial judge prefers the testimony of the syndicat's expert witness. He says, in the same way that judges prefer expert testimony of one side over another in all kinds of other cases, I find this more compelling, it's more coherent, I think it makes more sense.
And he grants the injunction, and he prohibits the construction of sukkah on the people's balcony.
Exactly. And then they appeal. The sukkah builders lose again at the Court of Appeal, and then finally further appeal to the Supreme Court of Canada. Now, one interesting thing about this case, by the numbers, there were more judges who sided with the syndicat than sided with the co-owners if you add up all the judges at all the stages, right? So 1 judge at trial, 3 judges at the Court of Appeal, and 4 judges at the Supreme Court of Canada all sided with the syndicat. But because 5 judges at the Supreme Court of Appeal sided with the co-owners, that ends up being the result in the case.
It was a majority decision 5-4. The majority allowed the appeal, overturned the lower court's decision, and they declared that the residents have a right to set up sukkahs on their balconies during the festival as long as they follow certain undertakings regarding safety and aesthetic.
This is a decision written by Justice Iacobucci, and Justice Iacobucci starts by defining religion. And he admits that it might not be possible to define religion precisely. He does say that religion typically involves a particular and comprehensive system of faith and worship. And religion also tends to involve the belief in a divine, superhuman, or controlling power. And then he tries to distill it all, and he says, in essence, religion is about freely and deeply held personal convictions or beliefs connected to an individual's spiritual faith and integrally linked to one's self-definition and spiritual fulfillment, the practices of which allow individuals to foster a connection with the divine or with the subject or object of that spiritual faith.
Freedom of religion should be defined broadly. Am I wrong?
No, you are exactly right. So I think part of this comes in response to the dueling rabbis. If I'm trying to get in the head of Justice Iacobucci, which I'm trying to imagine myself as a judge of the Supreme Court, or judge of any level of court, seeing 2 rabbis debating about what Judaism requires, I may become very uncomfortable because I might think, this is not my institutional role. It's not my job to tell members of any faith community how to practice their faith. It's my job to determine whether a law has interfered with the practice of their faith. And the way out of this conundrum of choosing one rabbi's testimony over another is by starting from this place at paragraph 39 that we just read. If you look at it carefully, the language is highly individualistic, right? It's about personally held beliefs and convictions rather than the dictates of a particular communally recognized body of principles, right? Personal beliefs. And that leads us down a path to what some have called the subjectivization of religious freedom in Canada. So now the test that we have coming out of Amselem, which has been remarkably durable. So just as Big M Drug Mart is cited in every subsequent 2A case, now since 2004, Amselem is cited. It is very firmly entrenched in our jurisprudence. It hasn't changed much in the past 20 plus years. And what it says is you need sort of 3 components of establishing an infringement of Section 2A. So if I'm coming to the court, I have to identify a law, and then first I have to show that I have a sincere belief in a practice, and that practice can be either obligatory or voluntary. But Justice Iacobucci says, for the same reason that courts shouldn't be in the business of deciding what Judaism requires, they also shouldn't be in the business of deciding what's obligatory and what's voluntary in a religious tradition. What's important is that it's connected to religion. So that's the second aspect of the test. So I have to show, 1, a sincere belief in a practice, 2, that has a nexus with religion. It must be connected in some way to religion. And 3, I have to show that the law that I'm complaining about is interfering with my ability to engage in that practice in a way that is more than trivial or insubstantial. When I teach about this case, or when I talk to other folks about this case and the test, usually the response is, well, isn't that a huge and sweeping right if it's all down to sincerity? And the truth is, I only have seen one case where the claim failed because the court found the claimant to be insincere. It's a case called Bothwell. So we don't see this sincerity hurdle as a huge filtering mechanism. But at the same time, we have not also seen a flood of litigation because of the breadth of this right. So we don't see large numbers of people addressing themselves to courts in a way that ties up the system as some have feared. So even though it's a very broad right, the counterbalance has also been, especially over time, that the broader the right is cast, the easier it seems to be for governments to justify those infringements.
The court is establishing some definitions. What do they decide in Amselem?
In the Amselem case, the court holds that all of the claimants had met the test in one way or another, whether they sincerely believed that they needed to have their own sukkah, or whether they showed a sincere belief that they needed to celebrate the holiday joyfully, and they had adequately proven the problems posed by the communal sukkah. So the complex was a fairly large complex, and for observant Jews, on several days of the holiday, using an elevator would be prohibited. So it would mean taking all of their plates and cutlery down several flights of stairs, walking to the courtyard, having their meal there, and then walking back up. And the court was satisfied that that was a less than fully joyful way of celebrating the holiday, according to the experience of these individuals.
It is not trivial.
No, it's not. And in the particular accounts of these individuals, which is what we should be focusing on, the celebration of this holiday was a religiously significant moment. And there's some basis for that in Jewish religious practice, right? So Sukkot is one of three major holidays where historically pilgrims would bring offerings to the temple in the time that it stood in Jerusalem. So it was seen as a major holiday in the Jewish life cycle. I think one of the other things influencing this case, and we see it in some of the language of Justice Iacobucci, was that the Syndicat just didn't have very much to put on the scales. As much as we might think it's not that big a deal for these people, whether they have their sukkah on their balcony or in a complex, does it really matter to the Syndicat that for 1 week a year, there's a few isolated little huts on the balconies? Does that harm the aesthetic of the complex in such a way that it might do something like decrease property value or decrease other co-owners' enjoyment of their own property? Justice Iacobucci, he says at paragraph 85, in practice, to what degree would the respondent be harmed were the appellants allowed to set up a sukkah for a period of 9 out of 365 days a year? Now, I should say Jewish years are not 365 days, so his math is a little bit wrong. But the point still stands, right? It's not a very big interference with anybody else's enjoyment of their property. The courts had held that the safety and security concerns of the Syndicat had been adequately addressed already by the undertaking of how the sukkot would be built and installed on the balconies. So ultimately, when we look at this fight and we see, okay, well, here's this individual who has this religious connection to building this hut, and it's 9 days a year, why can't the Syndicat just live with this in a way that wouldn't exclude observant Jews from buying units in this building?
These would be competing rights. How does the court manages everybody's sensibilities? And again, we're going back a little bit on equality.
It's a really good question. So first, in the Amselem case, one of the interesting things about this case, this actually on its face isn't a constitutional law case because it's based in the Charter of Human Rights and Freedoms. That's Quebec provincial legislation that applies only in Quebec. It's quasi-constitutional legislation, but it's not the Canadian Charter of Rights and Freedoms. The form of this case would not be reproduced in any other province. So what we have here is a dispute between private parties. Normally, when we're talking about religious freedom, we're talking about an individual against the government. So the Quebec Charter of Human Rights and Freedoms, in some ways, protects religious freedom in a wider way than do other provinces. All provinces have a legislation that prohibits discrimination, but only Quebec in the private sector protects religious freedom. Now, the court specifically says in Amselem, everything we're saying in the abstract about religious freedom under the Quebec Charter applies as well under the Canadian Charter of Rights and Freedoms. So even though I couldn't rely in Alberta on the Canadian Charter of Rights and Freedoms to fight against a condo association because the Charter simply has no application in that kind of dispute, I can rely on the Amselem case when I'm arguing a religious freedom case under the Canadian Charter because the court told me I could, and has since subsequently relied on Amselem in all kinds of Canadian Charter cases. So that's one thing in terms of balancing competing rights, because under the Quebec Charter, those property rights are equally protected. And what the court does in Amselem is it uses Article 9.1 of the Quebec Charter, which is the sort of Quebec equivalent to Section 1 of the Canadian Charter, and it does that kind of balancing exercise, right? Whether implicitly or explicitly, it's saying, okay, well, let's put these concerns on the scales and see which one weighs heavier. In Amselem, they determined that it was the co-owner's concerns which weighed more heavily. But there are other cases where even rights protected under the Canadian Charter come into seeming conflict. So we have seen in recent years, for example, the right of religious freedom brushing up either against the right of equality or against equality-related concerns. Trinity Western University said that it was going to try to start a law school. And the controversial part of it was that Trinity Western has what it calls a community covenant, where any student and faculty member has to agree to abide by a certain set of principles. The one that was most controversial was you're subject to discipline if you have sexual relationships outside of a marriage, and a marriage is defined as being between one man and one woman. The Supreme Court, in the Trinity Western case, it's asking, is the infringement on religious freedom proportionate to the legitimate government goal? And the legitimate goal in that case was seen as making sure that all seats in all law schools would be equally open to everybody in order to protect both the quality and the diversity of the bars in those provinces. Right? Most of these cases where there are fundamental rights on both sides come down to which one weighs more heavily. There are some cases where the court tries to reconcile the rights. One example of that kind of case is a case called NS, the sexual assault prosecution. The complainant said that her uncle and cousin had sexually assaulted her, and then she sought to testify while wearing her niqab, and the accused objected, saying that this was interfering with their fair trial. The court develops a multi-step test that attempts to reconcile the rights of religious freedom of a niqab-wearing claimant with the rights of an accused to a fair trial. Some folks have been critical of this test. It seems pretty clear that in a sexual assault case where there's no witnesses other than the complainant and the accused, that if a complainant wants to go ahead with the prosecution and the prosecutor wants to use the complainant's testimony, then the complainant will have to remove their niqab in order to testify. Some critics have said this is not really respecting the religious freedom rights of niqabi women, but that is one instance of the court sort of developing a multi-step test that at least reaches at reconciliation between those rights.
Let's go back to Amselem. This case has a fairly strong dissent. It's a 5-4 decision. Like you also stated, 7 of the judges that heard that case sided with the condo association. How important is that dissent? And what are your views on this?
So there's 2 different dissenting opinions in Amselem, right? So one written by Justice Bastarache and one written by Justice Binney. And Justice Binney's is the one that emphasizes the sort of freedom of contract angle. So he sort of asks, well, there's lots of different condos available in Montreal. Not all of them have this rule against things on balconies. Who better than a purchaser to decide on the appropriate condominium for themselves, knowing their own religious needs, especially given that in this case, there's no suggestion, no evidence that the rule was adopted in the first place to exclude Jews. So if the rule doesn't have any animus towards a religious group, shouldn't we hold people to their bargains? Justice Bastarache's dissent is a little bit more foundational on the nature of religious freedom. For Justice Bastarache, freedom of religion and maybe freedom of conscience are different things. And when we talk about freedom of religion, we're talking about religion as a communally experienced phenomenon. So membership in a religious group implies the existence of the group, and the group has its own rules. And it's true there may be some internal variation within members of a particular community, but ultimately we're governed by the same communally recognized precepts. So for Justice Bastarache, it wasn't that much of a problem that there were competing testimonies from expert witnesses in this case, because it should be the job of a complainant under Section 2A to establish that they are coming to court based on a legitimate religious precept. And that shouldn't actually be too hard for them to establish, right? If they're a member of a religious community, they probably have a religious leader who could testify to the nature of this religious precept. Now, there's something important in there, in that as much as the majority decision in Amselem has been lasting, it has been criticized by academics as being too highly individualistic, reducing religion to individual choices, which may prevent courts from seeing some of the more communal aspects and collective aspects of religious freedom. In a subsequent case called Hutterian Brethren, there was an objection by Hutterite communities to having their photos taken for driver's licenses. And you can see a division between the majority and dissent in that case. Everybody was agreed that this particular community had a religious prohibition on having their photos taken. That was common amongst the majority and the dissent. But the dissent also saw within the life of the Hutterian community that being as self-sufficient as possible was actually a communal religious obligation. And the majority in that decision decides to treat those communal elements only under the Section 1 analysis, not under Section 2A. So some have said that the majority decision in Hutterian is influenced by the highly individualistic approach taken by the majority in Amselem. We have seen in more recent cases a re-engagement with the idea of collective religious freedom. And some of those re-engagements cite the dissenting view of Justice Bastarache and also some words of Justice Lebel in other cases, who says, Justice Lebel said that, religion is not only about individuals, it's also about relationships. We may have seen in the last couple of years the court further broadening the definition of religious freedom to include not only those individual beliefs, but also the collective aspects of religious practice.
How did Big M and obviously Amselem impact Canadian society? How did they endure in time?
Yeah, really good question. I think that the decisions in Big M and Amselem, when you put them together, they really allow subsequent courts to take a very broad view of what counts as religious practice and what might be covered under Section 2A. And I think this is a healthy thing for Canada as a democracy as we become more and more religiously diverse. Right? As we were talking about at the beginning of our conversation, in the 1860s, religious diversity was thought of almost purely in Christian terms. And now when we see these cases, inevitably it's some religious minority community, like the Jewish community in the Amselem case. So because the right is framed in the way that it is, and it allows individuals to come to court and say, this is what I subjectively believe, it doesn't inappropriately filter out any cases based on some inherent bias from a judge's personal experience, right? A judge may be a member of a religious minority community, but more likely they're a member of a religiously dominant community or no religious community at all. And because of the limits of their experience, they may have trouble identifying what is a religious practice. And these tests, they cast the gate wide to allow a litigant to explain to the court, and there's quite a bit of work that litigants have to do to translate their cases into the terms that a court can understand, but the tests allow them that latitude.
Professor Howard Kislowicz, thank you very much for accepting our invitation, for sharing your knowledge on these important issues, important cases.
Thank you very much. Thank you for your very insightful and incisive questions. It was a pleasure to spend some time with you.
Thank you for joining us for this episode of Shaping Canada, 150 Years of Landmark Decisions. As we've explored today, the law is not static, it is living. Every Supreme Court ruling adds another stone to the foundation of our society. For links to the decisions discussed and more information about our guests, visit shaping-canada.ca and make sure to read the show notes. Subscribe on your favorite podcatcher so you don't miss any part of this series marking the 150th anniversary of the Supreme Court of Canada. Thank you to everyone who contributed to this project. the Supreme Court of Canada, the Right Honourable Richard Wagner, Chief Justice of Canada, the Honourables Nicolas Casirard, Suzanne Côté, Andromache Karakatsanis, Sheila Martin, Malcolm Rowe, Mahmoud Jamal, Michel Obonzawin, and Mary Moreau, Professors Louise Langevin, Jocelyn Downey, Carrie Frock, Naomi Metallic, Karen Drake, Denis Nadeau, Félix Mathieu, Éric Labelle-Eastaff, Marcus Moore, Joel Bakin, Howard Kislowicz, Richard Moon, and François Tanguay-Renaud. Thank you to Maître Michel Lebrun, Miss Sandrine Raymond, Laurence Laperrière, and Laurence Thériault, Mr. Peter Warren, and our producer, Constance Saint-Pierre. This project has been made possible by the Government of Canada. I am Hugo Martin. Until next time.